who've entered the webinar. Let's begin. My name is Brian Brannon, and I serve on the Chartered Institute of Arbitrators North America Branch Board of Directors and its Young Members Group Steering Committee. It is my pleasure to welcome you on behalf of the Chartered Institute of Arbitrators Young Members Group to the ADR World Tour, Arbitration and Mediation as a Global Force for Good. The Chartered Institute of Arbitrators Young Members Group presents a series of webinars from 11 different regions throughout the world, which cover ADR and access to justice, ADR as a means to strengthen the rule of law, and ADR as an efficient alternative to traditional litigation. Today's webinar features as the second of 4 features from Asia. We are pleased to be sponsored globally by the Benjamin N. Cardozo School of Law and the Korean Commercial Arbitration Board. In addition, we are pleased to have numerous global sponsors, including in Asia, the Malaysia Chartered Institute of Arbitrators branch, the Singapore Chartered Institute of Arbitrators branch, and the East Asia Chartered Institute of Arbitrators branch. We are grateful for our panelists, and I am extremely grateful for my friends and colleagues who are in charge of the central organizing group and organizing all 11 of our regional series of the ADR World Tour, Ishan Madan, David Chung, and Kirsten Teo. It's my pleasure to hand the microphone over to Kirsten Teo, who will moderate this exceptional panel at this time. Thank you, Kirsten.
Thank you very much, Brian. Hi, everyone. Welcome. I'm Kirsten, a Singaporean arbitration attorney at D. Almeida Pereira, based in DC, a young SIAC committee and SIAC Users Council member, and a CHARB member. Welcome to the second webinar in the Asia series of the CHARB YMG Global ADR World Tour 2021. Now, this project was brought to life by a central organizing team led by Brian and Team Asia, comprised of myself, David, and Ishan, who are all here with us today. We thank the Chartered Institute of Arbitrators for hosting this entire series and thank all of the collaborating organizations for making this possible, especially CIArb International and Cardozo School of Law. We are also delighted to have you all join us online from various jurisdictions worldwide, and we are thrilled to have Mino, Amy, and Jay here to share their perspectives from Korea, Singapore, the Philippines, Hong Kong, and the wider Asia region. Now, to encourage active engagement and knowledge sharing, the Chatham House rule shall apply in this webinar. The overall theme, as Brian has explained, is arbitration and mediation as a global force for good, inspired by the SEC Centennial Arbitrating for Peace Symposium in Stockholm. Specifically for this webinar, we will delve into mediation and hybrid combinations. The hybrid SIAC-SIMC Arb-Med-Arb protocol was established in 2014. It's a one-stop process where the dispute is referred to arbitration before mediation is attempted. As of February of 2020, there were 23 SIAC-SIMC Arb-Med-Arb cases involving parties from the BVI, Cayman Islands, India, Japan, Switzerland, Taiwan, Thailand, and the UAE. The settlement rate at SIMC is higher than 80%. Now, I've also encountered cases with a Med-Arb mechanism incorporated in contracts. The first mediation ends up being more of like a cooling off formality. It's a prerequisite. Some may say it's an obstacle to commencing arbitration. And at times after arbitration has commenced, the parties settle back at mediation. Now, the 12th of September 2020 is a special day for mediation. First, the Singapore Convention on Mediation entered into force, and Jay will share more about this convention with us. Second, the Japan International Mediation Center, JIMC Kyoto, and SIMC Singapore signed an MOU to operate a joint online mediation protocol to provide expedited mediation. Now, to kickstart the session, I would first like to invite the speakers to share 1 or 2 things about themselves, which Google does not know. Amy, please.
Hi, everybody. Good morning and good evening. One thing Google doesn't know about me is I'm not a circuit breaker baker, but a circuit breaker kueh maker. Anybody from Singapore, Malaysia, Indonesia knows that kueh refers to local desserts, little cakes, little things made from glutinous rice. So there's that. Back to you, Kirsten.
Oh, that makes me homesick for kueh now. Amy, thank you so much.
Kueh salad, kueh dar dar, anything you want. I can make them all now.
That's awesome. Kind of have to learn some from you. Thank you, Amy. And how about Mino? Is there something that Google doesn't know about you? We'd love to know.
No, Google does know everything about me. I work in Korea in a dispute specialist boutique firm. I'm qualified as Korean lawyer, but not many know that my first language is German. Grew up in Germany for a very long time. So if you're confused with a Korean lawyer speaking English with a slight German accent, don't get confused.
Oh, that's wonderful. Dankeschön, Mino. That's awesome. And Jay, please share with us something that Google doesn't know.
I'm not sure if I need to disclose this, but once upon a time, I played a major role at a musical production.
Oh, cool.
That's not in Google.
Oh, that's wonderful. Was it like Broadway or, something?
No, it's a local production here in the Philippines. It's a musical production of Rent.
Oh, I love that. I love that musical. That's so interesting. Thank you, Jay. Thank you, Amy and Mino.
If we have some time left over, we should get Jay to sing something at the end.
We should all go to karaoke when we meet.
And maybe we can set up an arbitration band. Just saying. So thank you so much. And to everyone, thank you for joining us today online from wherever in the world you may be. We welcome you. As a roadmap for the program today, I'd like to just provide the following points. Amy will start by providing us with an overview of the various ADR mechanisms, followed by Mino, who will share his perspectives from Korea on litigation and ADR forms. Jay will then provide an overview of the Singapore Convention, the challenges faced, and the way forward. And in the last segment, the speakers are welcome to share practical tips and highlights from your various experiences and advice on how one can gain knowledge about mediation and arbitration. So without further ado, I'm really excited to welcome the speakers to share their insights on these topics. So first, to kickstart the discussions, I'd like to welcome Amy to present. And by way of introduction, Amy is a partner at Drew & Napier in Singapore. Amy represented the National University of Singapore in the Vismut in 2011. She teaches civil procedure and advocacy to future lawyers as part of the bar course and sits on the advocacy committee of the Law Society. Amy has also taught the advocacy course at NUS and continues to be a part of the NUS Law Alumni Mentor Program. So I'd like to welcome Amy to share her thoughts on ADR. And at this point, I'm happy to share Amy's slides. Amy, please.
Thank you, Kirsten. Hi, everybody again. First, I'm going to seek your indulgence and patience because we have a very wide variety of attendees today. So it's going to go a little bit back to the basics. I think Kirsten mentioned to the panelists when we were discussing ahead of this webinar that there was in-house counsels, there were people who are really new to the practice. And so we just wanted to give a very quick overview of all the alternative dispute resolution types before talking about tiered dispute resolution clauses and then leading into the other two speakers' presentations. Okay, so on the first slide, just talking about alternative dispute resolution. This really refers to, well, settling disputes outside the courtroom, any means of them. And you'll see a list of different types of ADRs out there. This is not an exhaustive list. And depending on the jurisdiction you are from, it could be really called something else. So very quickly, I'll just introduce these different types of ADR and then talk about tiered dispute resolution clauses. Now, the first one is negotiations. This is just generally used to refer to discussions between the parties to resolve issues informally. It can be done in a meeting, it can be through the phone, it can be just the parties, it can be with lawyers. Usually that's the first port of call between lawyers between the parties when there is a dispute. It could be, though, contractually provided for, and we'll talk about that in a little bit. Neutral evaluation, maybe not all jurisdictions have this, but effectively this is a situation where you have a neutral third-party evaluator who will review the case and provide an early assessment based on the merits. Really depending on what parties want to evaluate, it could be the whole case, specific issues, maybe issues with quality of goods delivered, that sort of thing. Effectively, you're asking a third party to provide his best estimate of the party's likelihood of success, whether at trial or arbitration. It can be binding or non-binding. Now, moving on to conciliation. This word really means different things in different countries. In Singapore in particular, conciliation is actually part of the court dispute resolution process. So when you start a case in the state courts, you are offered conciliation as one of your ADR mechanisms. Basically, you have your case being sent to one of the judges, and parties can seek guidance from the judge to tap on his experience and knowledge to come up with an optimal settlement. It's not binding on parties. It's really just for you to explore, cool the air, and maybe just have a chance to chat with the other party and see whether there is a chance at settlement. Now, conciliation is also something that will be touched upon by Mino in his presentation, so look forward to that. Mediation. Now, mediation, one of the two big topics we're going to talk about today, mediation and arbitration. Mediation is basically, once again, a neutral third-party mediator who helps to facilitate and guide the parties in negotiating a settlement that is mutually acceptable to both parties or more parties. He's not here to determine who's at fault. He's here to find solutions that can meet everybody's concerns without forcing anybody to do anything. It can be ad hoc, it can be with an institution. You can choose your mediator, or if parties cannot agree, you can ask usually the institution in your country to then appoint a mediator. In this case, or in Singapore, our main institutions are Singapore Mediation Center, Singapore International Mediation Center. And I just wanted to say that mediation as a whole generally ends with a signed settlement agreement. And this then might be enforceable pursuant to the Singapore Mediation Convention, which Jay is going to talk about in his presentation. Arbitration, I'm sure most people listening in know what arbitration is, but just to complete the issue, basically it's a process where parties refer their dispute to a neutral third party to decide. The arbitrator or the panel could be lawyers, experts in their field. It could really be anybody, your mother, if you really wanted to. But during the hearing, parties, they present their case. Lawyers are usually involved, and there is a binding decision that results in an award, which can be enforced through the courts under the New York Convention. This can be ad hoc, it can be institutional. In Singapore, we have the Singapore International Arbitration Center. We also have the Singapore Institute of Maritime Chambers. Okay, the last one is arbitration and dispute boards. Sorry, adjudication and dispute boards. Now, this basically refers to everything else that's not arbitration, mediation, yeah, it covers a lot of different things. In Singapore, adjudication, I think, is most widely recognized to be in conjunction with the construction. So in Singapore, under the Building and Construction Industry Security of Payment Act, you can apply for adjudication, which is a short, fast decision on payment where, in case, for example, the employer doesn't pay the main contractor, pay now, and then finally later we can argue about the full suite of issues in an arbitration. Other areas of things relating to adjudication could be things like the Securities and Exchange Board of India. And then coming to dispute boards, in Singapore, we have a whole range of them. Financial Industry Disputes Resolution Center, FIDREC, which resolves disputes between financial institutions and consumers. Strata Title Board, which resolves strata title properties, disputes in relation to, for example, collective sales. We also recently, SIMC has a Singapore Infrastructure Dispute Management Protocol, which has a dispute board to help parties manage basically large disputes in relation to mega infrastructure projects. And I can go on and on about all the different types of this, but we must move on. So we just want to give some overview to everybody about some of the considerations you may have in choosing the ADR methods when a dispute has arisen, or ADR methods when you're trying to draft the contract. This is just a list of different types of considerations that you might want to take into account, whether for yourself as an in-house counsel or for your clients. The first one I put right at the top is confidentiality, because to me, and I think for many of my clients, this is one of the most important things. If you need a confidential process, then you're obviously much more limited. If the contract doesn't previously provide for confidentiality, if you want to go for mediation, you might want to make clear that that's one of the basis on which you guys go for any of the other ADR processes. Most clients or litigants are concerned about things like costs, duration of the dispute resolution process, extent of their control over the outcome of the case. And on the extent of control point, really it's, for example, if you want to renegotiate the terms of the contract, then, and you want to provide, for example, an alternative that's not within the four walls of the dispute, you can't really do that in arbitration per se. You will have to do it, for example, in mediation or some sort of other discussions, negotiations, etc. And I suppose one of the other things I just want to point out on this list is some parties do want very specific subject matter knowledge. So, sorry, let me rephrase that. Some parties want their evaluator, mediator, or arbitrator to have very specific subject matter knowledge because of the field or the type of dispute that they are in. And if that's the case, then sometimes you might not want to go to, for example, courts, or you might not want to allow the institution to appoint your mediator or arbitrator for you. So looking at this list, I think one needs to consider what's important and choose the best option that addresses your needs or the client's needs, right? But as a whole, I think mediation is generally regarded as the default ADR option because it addresses most of the concerns usually faced by litigants. But for example, if assessment of merits is very important to you, then neutral evaluation, arbitration may be more suitable. Now, moving on to the next slide, what I've done here is just to pull this out from the Singapore State Court's website. This is something that I sometimes show to my clients who have very little idea of what ADR is. It's just really a summary of the pros and cons for the different types of ADR available under state courts, but it's very applicable to, I think, most disputes. It's a good guide to have if you're trying to consider what type of ADR to go under. Okay, I'm running out of time, so we're going to move on to tiered dispute resolution clauses, and this is really to set up for the discussion today. What is a tiered dispute resolution clause? If you do not already know, when you read contracts, sometimes they will say, first, if there is a dispute that arises, the two CEOs must talk to each other and try to resolve the issue within 5 days. Then next, there needs to be a notice that is sent in relation to set out specifically all the different disputes. 20 days needs to pass. I mean, things like that. It could really go into great detail about all the steps that need to be followed before parties finally refer the dispute to, let's say, arbitration or litigation, whichever jurisdiction. And it's important to follow the steps set out in this clause to avoid challenges to the tribunal's jurisdiction. But amongst these 5, the question is which one is good for you, what actually works. And that really depends on the facts of your case and what is best for you. Negotiation usually is something that's set out in a tiered dispute resolution clause if it's a big MNC. So you have a lot of levels of sort of authority to go through. You want people to first, I say the minions first discuss, and then you have C-suite level people discussing, and then maybe a final ditch effort, actual mediation before you finally go to arbitration. Now we've listed at the second point, Med-Arb. This was something that was mentioned by Kirsten earlier. This was the sort of previous iteration of, I would say, joint ADR clauses where you would refer something to, the dispute to mediation before arbitration. I just wanted to say that there was a case in Singapore in the High Court in 2017 involving a Med-Arb clause. So it required the dispute resolution clause there required parties to submit disputes to the SMC and then the SIAC. So, the plaintiff that wanted to claim against the defendant started mediation under the SMC, but the defendant just flat out refused to do anything in relation to the mediation, refused to take steps, refused to attend, refused to pay the filing fee, that sort of thing. And the only thing that the plaintiff could do was to, basically apply to court and set aside, or rather bring the contract to an end on the basis that the defendant has committed a repudiatory breach of the arbitration agreement. But then in that case, you are then left with having to go to court and not being able to arbitrate, which was originally provided for by the parties. So that was one of the maybe downsides of Med-Arb back then. And then now we have Arb-Med-Arb. Now, what is Arb-Med-Arb? Like Kirsten said in her introduction, You start with arbitration. In the middle, you go to mediation. If you get a settlement, it can be recorded as a consent arbitration award, which can be enforced under the New York Convention in more than 150 countries. And that's something that I'm just going to show you the model clauses in a couple of moments. And the last point, when we put a question mark, and that's really the title of our webinar today, Med-Arb-Med, we are asking, is it possible to start with mediation, go through a process of arbitration, and then, like Kirsten says, try mediation again and end with an international mediation agreement that may then perhaps be enforceable under the Singapore Mediation Convention. So I'm just going to end quickly by showing you three model clauses under Singapore, 3 different Arb-Med-Arb clauses. The first one is the SIMC or SIMC Arb-Med-Arb model clause. This is between the Singapore Chamber of Maritime Arbitration and the Singapore Mediation Center or Singapore International Mediation Center. You will see that it's a one-stop shop. You refer it to SIMA, and then within that you do a mediation. Now the next slide then shows you the Law Society arbitration scheme. This is new, and this is really mostly dealing with domestic disputes, but the costs are lower. So, if you are an in-house counsel and you're looking to consider mediation or some sort of tiered dispute resolution clause, you can look at this. And then the last one is our favorite, leading the pack, SIAC-SIMC Arb-Med-Arb clause. And they have a protocol as well. So under the protocol, basically your mediation only takes 8 weeks, or rather there's only 8 weeks that's been set aside for parties to do the mediation. The best part about this is it sort of progresses the case. You've started the arbitration, you take 8 weeks to try to do the mediation. And then if that doesn't work, you just go back to arbitration. There's no issue of, for example, the defendant or the respondent trying to delay matters, which is one of the other problems that Kirsten had mentioned at the start. Okay, I'm a little bit late, but that's all I have for today, unless anybody has any questions.
Thank you so much, Amy. And I think it might be a good time now for audiences to take part in the poll. And I'm going to launch the poll. Please take your time. You have a few seconds to answer. So the question is, which dispute resolution forum is most prevalent during the pandemic? You can choose the top 3. And so, Amy, we'd be happy if you could share some of your views on this question. What, in your view, from the varieties given, do you think is the most common?
Right. Thank you, Kirsten. I think during the circuit breaker or the pandemic, I have found that there's been a shift towards strategic thinking or trying to resolve the issue by either renegotiating to lower, certain rates that are being paid out, or to look at really a much longer term relationship. I feel during the pandemic, there was a great concern about being fiscally prudent, not sort of spending money on litigation and arbitration unless it was really crucial and absolutely necessary. So right. I chose one of the last options there.
Right. Thank you so much, Amy. And so I'd be happy to share the results with everyone. So let's take a look. Well, it looks like majority of you have voted for mediation and negotiation, followed by arbitration. Very interesting. Thank you so much for participating in the poll. Wonderful. Thank you, Amy. I now would like to invite Mino to present. And while Mino is setting up his slides, I'd like to introduce Mino. Mino is a partner at Peter & Kim in Korea. Mino majored in law at Seoul National University, after which he passed the Korean bar exam in 2006 and qualified as a Korean lawyer in 2009. He received a Master of Laws degree in International Arbitration Law from Seoul National University in 2012, and a Master's in Science degree for Construction Law and Dispute Resolution at King's College London in 2018. In 2019, Mino was admitted to the role of Solicitor of England and Wales. I welcome Mino to share his perspectives from Korea. Mino, please.
Thanks, Kirsten, for your kind introduction. almost like an inauguration.
Oh, it's happening pretty soon. Here in DC.
I was asked to share a few words about Arb-Med-Arb, or Med-Arb-Med, or Arb-Med, or Med-Arb, and I was wondering, what is that? What I understood from this is to share my experience about mediation being used and mixed as part of an adjudicative process. And I thought, okay, let's take a snapshot as to how we do it in Korea. Is it done well? How is it done differently? And what can the Singapore Convention or the SIMC scheme learn from this? What can we learn from other best practices? So I'm here to share a few words about how we do it in Korean litigation, in Korean domestic arbitration, and a glimpse into Korean international arbitration by the KCAB. Before I jump into my slides, and they aren't very long, just wanted to give you a bit of a cultural background and context, which I shared with the speakers during our prep call. It's my observation that parties in Korea tend to either not go to an adjudicative process at all. They don't go to arbitration. They don't go to litigation, try to negotiate and settle the dispute before it becomes formal. Or when they begin the fight, they want to see the end, bloodbath, and you really want to see the outcome, the judgment from someone who is more authoritative, more superior to you. So one might ask, okay, if it's either or, is it really used in practice that mediation is mixed with litigation or mixed with arbitration? And my answer to that is actually yes, but slightly different because of this culture. And we can discuss this further during our discussion rounds. Now, how is it done in litigation? This is my first area that I wanted to touch on. Mediation is used during litigation a lot. We have even a special act to facilitate the use of mediation during litigation. Now, what's interesting is that the term used is conciliation. It's not mediation, and it has a slight nuance difference. Mediation is more often used as a term where parties have a facilitator sitting in the middle, he, she, facilitating a settlement. Conciliation is someone giving you a recommendation. It's sort of a direction. It's more guided. So use of conciliation or mediation during litigation is common. The court may refer the dispute to mediation or conciliation at any stage, not only at the beginning. Who's the mediator? It varies. It could be the judge, him or herself. It could be a separate conciliation or mediation judge, or it could be standing mediation / conciliation commissioners, retired people who have wisdom and are respected in our society. Also, as I mentioned, a decision in lieu of conciliation or in lieu of mediation could be given. This is sort of a recommendation which parties can object to within 2 weeks from that decision. The decision has no reasoning, so it's not like a judgment. You can take a look at it. If you like it and don't object to it, it becomes fixed as a judgment. If you don't like it and object within 2 weeks, then you go back to litigation. So it's a bit of a hybrid. It's not a real mediation as we know it in the Western world. It's sort of a hybrid between judgment and mediation. It's used a lot. That translates into Korean domestic arbitration because Korean domestic arbitration is often led by a panel composed of former judges or Korean lawyers with little international exposure. So you do it in a way how you do it in litigation. How do you do it? You introduce mediation or conciliation during the domestic arbitration process at any time. It's stipulated in the KCAB Domestic Arbitration Rules 39, where it says the parties may, at any time during the arbitration process, request mediation of all or part of the dispute. And even the tribunal informally invites the parties to go into mediation or conciliation. So compared with the SIAC-SIMC Arb-Med-Arb protocol, the timing is different. You can do it anytime. More often you do it at the later stage of the proceedings once the issues are more crystallized and the dispute has more ripened. In the CIArb domestic arbitration rules, there is also a provision or a sub-provision stating that unless the parties agree otherwise, no party may use the statement of the other party or witnesses of the mediation in the arbitral proceeding. So it's made very clear in the rules, you don't mix it up. You don't get those two things mixed. It also states that when the mediation procedure concludes, the arbitral tribunal shall reopen the arbitral proceedings upon the party's request. Now, that's what's stated in the rules. How is it done, though, in practice? It's in slide 4. Often the tribunal does recommend or does suggest to the parties in a domestic arbitration setting, do you want to settle the dispute? We think that the claimant has a better chance to win. It sounds very non-independent, slightly non-impartial, but the mentality that domestic arbitrators still have is that we are sitting here as quasi-judges. So they are very leading the process in a way that feels like a court proceeding. In Article 39 that I just walked you through or touched on could be thereby circumvented. No measures are provided for in the domestic arbitration rules as to prohibiting the tribunal from asking the parties informally, do you want to settle the case, we think. That could lead into risks and pitfalls because it could lead into impartiality, it could lead into bias, it could lead into loss of neutrality. And although we didn't have a court case yet in the Korean courts dealing with this issue, I've come across a number of instances in the Asian region where this became an issue. And I'm not going to study and explore these cases I have on slide 6 in detail, but we have Singaporean cases, we have Hong Kong cases where the mediator was the same person as the arbitrator and approached parties or related entities of the parties and went into trouble later at court stage, at enforcement stage. Or in Singapore where mediation and arbitration procedural aspects weren't complied with and led into problems at enforcement stage of the award. So if you don't take care of the steps, procedures, and try to circumvent things by just simply adopting the mentality of a court proceeding, you may run into trouble during enforcement stage. So flagging this here. What about international arbitration? The rules, the CIArb international arbitration rules, which exist separately from the domestic arbitration rules, are silent about Arb-Med or Med-Arb or Arb-Med-Arb or Med-Arb-Med. Seems possible though, it's not clear, but seems possible from reading the international arbitration rules, which provide that if the parties reach a settlement after the request of arbitration is filed, and of course the costs are paid under the rules, the arbitral tribunal may render a consent award recording the settlement upon any party's request. So the rules are foreseeing a mix of mediation or settlement, at least settlement, during the course of arbitration. It seems that it's not forbidden, but there is, on the other hand, no set rules or no set protocol as to how it should be done. So what's next for the Korean arbitration community and society? I propose robust procedural requirements is a good way to structure Arb-Med-Arb. If you do it in a more foreseeable way. More important, I think, is the third bullet point that I put down. Not only rules or procedures or protocols, but also best practices. How is it done in other parts of the world? How is it better done in for instance, the SIAC-SIMC model? What can we learn from that? So introducing best practices and success stories, sharing them also from our end is very important in my view. So that's about it, what I had in my slides. And unless I have any questions, I'm happy to turn back the mic to Kirsten. I hope I didn't steal too much of your time.
No, thank you so much, Mino. That was very insightful. I'm curious, in some jurisdictions, it's very normal to double hat as mediator and arbitrator. I was just wondering what your thoughts are about this double hatting process. And in the meantime, while we await for Mino's view, I would like to also launch one of the poll questions for everyone to participate in. But one question that does come out from your presentation, I'm curious to know, is that in some countries, double hatting mediator arbitrator doesn't work. And it's actually not acceptable. But it seems in other countries like China and perhaps in Korea, it's more acceptable. Just wanted to know your thoughts on that.
I think it's a matter of trust of the parties, which comes from the culture, I think. And on that basis, I'm not saying that double hatting is a no-no in every case. It could be utilized in a very efficient way as long as you do it in a structured way. Not suggesting that the arbitrator should spill out his or her view on the prospects of the case and thereby try to settle the case. I'm not suggesting double hatting in that way, but as long as you do it in a structured way, I think it could be utilized efficiently to resolve a dispute. So I'm not a strong objectionist to that idea as long as it's done in a measured and structured way.
Understand. Thank you so much, Mino. I'd like to share another question. What is the most pronounced benefit ADR is playing during the pandemic? So I'm just going to launch this poll question. Everyone is most welcome to participate. And at this juncture, I would like to then invite Jay. And while Jay is setting up his presentation, I'm happy to introduce Jay. So yes, thank you so much for participating in the poll. I see it. Thank you. Please keep your answers coming. You have 30 seconds more. So in the meantime, I'll now introduce Jay. Jay is a senior associate in Quisumbing Torres Dispute Resolution Practice Group. In 2014, Jay became the first Filipino counsel at the HKIAC. In 2016, he became HKIAC's first accredited arbitral tribunal secretary from the Philippines. He is a trained arbitrator of the Philippine Dispute Resolution Center and an accredited arbitrator of the Philippine International Center for Conflict Resolution. He plays an active role in many, many ADR organizations. So many that you'll have to read the bio to know. And you wear many hats, Jay, so the floor is yours.
And the musical star.
Yes, the musical star as well.
Oh no, what have I gotten myself into? All right, can you hear me clearly? Hold on, see if it's right here. Okay, can you hear me, Kirsten?
Yes, perfect.
Okay, great. So good afternoon, good morning, good evening to everyone. I am given the task to discuss about the Singapore Mediation Convention. Let me just start my timer. And also a little something about online mediation. So you've been hearing about the Singapore Mediation Convention earlier from our first two speakers. Some of you might have already heard about this, but I understand that we have varying degrees of expertise among our audience right now. So please bear with us if we try to give a much plainer introduction of the Singapore Mediation Convention at the moment. So the Singapore Mediation Convention is actually a short name of a UN convention called the United Nations Convention on International Settlement Agreements resulting from mediation. Take note of the term international. It is a settlement agreement and it's resulting from mediation. It entered into force on 12 September 2020, so over a year now. There are 53 signatories, but as of today, if I'm not mistaken, only 6 have ratified and are considered as parties to the Singapore Mediation Convention. When the Singapore Mediation Convention was signed, it was the headline of the ADR community because the Singapore Mediation Convention is contemplated to mirror the success of the New York Convention, which is the enforcement convention for foreign arbitral awards. And as we know what happened with the New York Convention, many of its provisions have been adopted by the UNCITRAL Model Law on International Commercial Arbitration. And both the UNCITRAL Model Law and also the New York Convention are very, very successful nowadays with over 100 jurisdictions adopting them. Now, for the Singapore Mediation Convention, we've had this convention since, I think, 2019, when it was first signed, August 2019. But because of the signatory requirements for it to be effective, it actually also entered into force only last year, 2020. Hopefully, we will have a much more successful Singapore Mediation Convention in the future. So based on the name of the title of the actual convention, we note that the Singapore Mediation Convention applies to international settlement agreements. International settlement agreements resulting from mediation in which the parties resolve a commercial dispute. It ensures that, as I mentioned earlier, ensures that there is a binding and enforceable mechanism for the enforcement of international settlement agreements. Now, one of the criticisms about mediation before is that there is a lack of mechanism for cross-border enforcement. And that's why parties at the time, even if you look at the Queen Mary survey on international arbitration, there is a survey that says that parties in a cross-border dispute they prefer going to arbitration because of the cross-border enforcement mechanism for foreign arbitral awards. At the time, there was no Singapore Mediation Convention, and they had an issue about mediated settlement agreements being enforced cross-border. With the Singapore Mediation Convention, hopefully, the parties in cross-border disputes would now consider mediation as a more viable, hopefully cheaper, and also a more cost-effective mode of resolving their cross-border disputes because of the cross-border enforcement mechanism or framework brought about by the Singapore Mediation Convention. Just note that the Singapore Mediation Convention complements the UNCITRAL Model Law on International Commercial Mediation and international settlement agreements resulting from mediation. So just note that there is also a model law for international commercial mediation. Of course, states will have to adopt this model law on international commercial mediation so that their laws would complement also the enforcement mechanisms brought by the Singapore Mediation Convention. Hopefully, more countries in the future will adopt this law and also ratify the Singapore Mediation Convention so that enforcement of international settlement agreements would become more successful in the future. Now, I mentioned some of the words that I highlighted about the Singapore Mediation Convention is that it applies to international mediated settlement agreements. The convention defines what international is, and it kind of mirrors the definition of what is international in the UNCITRAL Model Law on international commercial arbitration. So if two parties are from different states, then you have an international mediation. And if they have the same places of business, the parties' place of substantial performance is different, and the subject matter of the settlement agreement is connected to another state. Now, I mentioned earlier that the mediated settlement agreement should cover commercial disputes, and that is why it does not apply to settlement agreements that are enforceable as a judgment, right? It does not apply. It also does not apply to settlement agreements that were approved by a court or concluded in the course of proceedings before a court. It should be related to a commercial matter, and therefore those that are concluded for personal, family, or household purposes will not be enforceable under the Singapore Mediation Convention. Okay, obviously, if it's not an international mediated settlement agreement, you cannot use the Singapore Mediation Convention to enforce it. As I mentioned earlier, the Singapore Mediation Convention provides a mechanism for the enforcement. And that is why if you look at the provisions of the Singapore Mediation Convention, it actually requires the courts to enforce a settlement agreement in accordance with the conditions laid down in the convention. It also allows a party to invoke the settlement agreement in accordance with the local rules of procedure. Just like the New York Convention, even if there is a requirement for courts to enforce, there are also grounds to refuse enforcement. Later on, I'll be discussing more about these grounds for non-enforcement. Particularly for now, it's suffice it to say that they are quite similar to what are provided in the New York Convention, but there are some interesting grounds here that I think needs more discussion so that it's clearer how these will apply in practice. Okay, now just some thoughts here. At the moment, there are very few parties to the Singapore Mediation Convention. We do need more parties to make this a truly international and successful convention that would allow the enforcement of, cross-border enforcement of international mediated settlement agreements. More ratification is required. Now, these are just some of the grounds or provisions under the Singapore Mediation Convention. It says that the convention does not apply to settlement agreements that have been approved by a court. Now, I wonder what will happen if a settlement agreement has been concluded in the course of a quasi-judicial proceeding, not necessarily by a court. Now, is this something that is covered by the Singapore Mediation Convention? The convention also defines the meaning of mediation, defines mediation. What if the local law of the, let's say, the applicable law to the mediated settlement agreement has a different definition of mediation? For instance, mediation under the Singapore Mediation Convention has a very broad definition. In the Philippines, if you look at the definition of mediation, it appears that that definition is narrower than the definition of the convention. The Philippines currently has not adopted the model law on international mediation. So this is not a problem that is unique to the Philippines. In fact, many countries have not yet adopted the model law, and therefore the language of the mediation convention and the language of the local laws in most countries do not match. As I mentioned here, the definition of mediation can vary. It also mentions that there should be an evidence that the settlement resulted from mediation if you are relying on a settlement agreement under the convention. Interestingly, some of the grounds include that the mediator, you can show that the mediator signed the settlement agreement or the document signed by the mediator indicating that a mediation was carried out. Query whether a mediator would actually sign the settlement agreement. Remember, in a settlement agreement, it is between the parties. The parties sign the settlement agreement, and the mediator merely facilitates the discussion and the signing of that settlement agreement. In fact, in practice, at least those that I've seen, mediators will not sign. And in the Philippines, the mediator is only required to certify that he or she has explained the contents of the settlement agreements to the party. He or she does not have to sign it. Now, the convention also requires the competent authority, provides that the competent authority may require the production of necessary documents to verify the conditions or requirements of the convention. It's not really set out what these conditions and requirements are, and could be, very, very dependent on the whims of judges, especially those who are not very experienced and knowledgeable about the mediation convention. Now, there are also grounds for refusing relief, which I think are worth discussing about. When one of the grounds provides that a party to the settlement agreement was under some incapacity. What do you mean by some incapacity, right? It's a very vague phrase when you say under some incapacity. And also another ground is if the settlement agreement is not capable of being enforced because it is not clear and comprehensible. It is a very subjective, I think, criterion for not enforcing a mediated settlement agreement. A party can always just say it's not clear and comprehensible. It really depends on the circumstances of the party invoking it. Another thing is if there was a serious breach by the mediator of standards applicable to the mediator or the mediation. What are these standards? Is that there are some jurisdictions where there are no standards yet, and which body would define these standards? Should it be the government? Should it be a private body? Whose standards are we going to follow if, for instance, the parties have not expressly agreed on these standards? Another thing here is, obviously a mediator who is a neutral should be independent and impartial. But interestingly, there is a language here that justifiable doubts that materially impact or unduly influence a party, without which failure that party would not have entered into the settlement agreement. It's this statement here, without which failure that party would not have entered into the settlement agreement. That's quite interesting. That's again a very subjective ground to not enforce a settlement agreement. Another ground here, another thing that we need to, I think, look at when we're looking at the mediation convention is that the convention shall not deprive any interested party to avail itself of any rights or remedies allowed by law or treaties of the contracting state. There are already currently some mediation laws that apply to local jurisdictions. And for instance, in the Philippines, we already have an enforcement mechanism of mediated settlement agreements, even before the Singapore Mediation Convention. Arguably, that also applies to international mediated settlement agreements. What is now the interplay between this convention, once it's ratified by the Philippines or another country, as vis-a-vis the current local remedy for enforcing mediated settlement agreements? There can be differences in the grounds for enforcement or non-enforcement, and there needs to be some legislation or some form of guidance, maybe from the judiciary, on how these two interact with each other. Now, just a few pointers that we've discussed during with the team before. They said that because it's the pandemic, it is timely to discuss about online mediation. Online mediation is something that is gaining popularity these days, especially because of the pandemic. We can't go out. However, just note that online mediation has been happening before, although not as popular as now, because it's more convenient. It fits certain instances, such as when a party does not want to be physically together. And it's also easy to share documents. And also, obviously, it's much cheaper if we do online mediation. There are, of course, practical issues that you need to consider, such as technical difficulties, confidentiality, lack of face-to-face interaction, which means that you cannot really catch nonverbal cues. Also, there is a lack of focus, because it's very easy to be distracted when you're looking at your computer. You have your Viber message, you have your Facebook Messenger, an email coming from a colleague, and that will easily distract you from the actual mediation. Of course, cybersecurity is also a huge problem. And there's also a psychological effect because of, for whatever reason, you're frustrated with all the technical difficulties or you're struggling to concentrate. Some legal issues that you need to take into account that is unique to online mediation is the e-signatures. How will you now sign the mediation agreements and the settlement agreements? You will have to look at the law applicable to the mediation agreement or the settlement agreement to ensure that these documents can be electronically signed. There are also formal and substantive requirements from local law. What do you mean? So it's really important for one to look at the requirements of local law to ensure that all of those requirements are met in an online mediation. There's also been some talk about attorney-client privilege, such as when there is a breakout room and the client and the lawyer are talking in one breakout room, and for some reason, the mediator comes in and heard whatever discussion was made, and therefore breaching, putting that discussion away from attorney-client privilege. So those are just some of the unique practical and legal issues that you could encounter in online mediation. Just feel free to send me a LinkedIn message if you have any further questions. Thank you.
Great, thank you, Jay. We do have a question from the audience. The question is whether the Philippines has ratified the convention. If so, great. If not, any indications of the reason why? And while we're pondering over this question, I'd like to initiate the next poll question.
All right. Well, the Philippines has not yet ratified it. It has signed it last August 2019. It's one of the first to sign it during the launching of the Singapore Mediation Convention. The Philippines is certainly studying, and I think it's only a matter of time before it ratifies it. And just to note, I see in the audience the current and the past executive director of the Philippines Office for Alternative Dispute Resolution, which is in fact the government agency tasked to push forward the ratification of the mediation convention. So hello to Bernadette Ongoko and Irene Alogok.
Welcome to both of you. It's a great presentation. Thank you, Jay. And I'm just going to give a few more seconds for everyone to key in their votes. Great. So these are the results of the question. Looks like most of us have voted for technologically advanced methods. Thank you so much. Thank you so much for participating. And I was just wondering, Jay, on the Singapore Convention, there has been some talk here, I think in the US, as to whether the Singapore Convention applies to investor-state disputes. And I think even though the term commercial arises so often in so many places in the Singapore Convention, I think the preference is to suggest that it likely applies to investor-state disputes, unless one of the countries, opt out and reserve their rights under Article 8. So I think so far, to the best of my knowledge, I think the only 3 countries who have made the reservations under Article 8 are Saudi Arabia, Belarus, and Iran. And I just wanted to mention this as a prelude to the next webinar, which will be moderated by my colleague David, as to the Asian perspectives on ISDS reforms. So I do think that Jay's presentation on the Singapore Convention ties in really nicely to the next webinar. Great. And if there are any more questions, please keep them coming. I'd like to now segue to the next topic, which is the 4th and final question. And I would like to invite the panel speakers to share their thoughts. We've discussed in the Singapore Convention, the limitations and the way forward. I think it's still quite early days. So we'll have to wait and see. And maybe we'll invite Jay again to come and give us the progress update, where we are today and where we are in the next few years. So at this point in time, I think there's some in the audience who might be keen to know how one can enter the field of mediation and arbitration. And we have a great group here. I'd like to invite perhaps Amy to share a few words on any practical tips how one can enter or survive this practice. Amy, please.
This is a CHARB event, right? So we're going to plug, just go and attend the CHARB courses, whether it's on how, being an arbitrator or whether it's about construction adjudication. There's plenty of courses out there. Go check out the website. But I think in general, if you're interested, maybe write articles that really gets your name out there. Talk to the professors, who are dealing with arbitration in your particular jurisdiction. I think as a basics, these are some of the basic steps that you can quite easily achieve, I think.
Right, thank you, Amy. And what about Mino? Any thoughts on this question?
If a junior were to ask me the same question, I would personally advise not to start off with mediation. It's important to me. It's important to know, in my view, to have an idea as to how the dispute will ultimately unfold. If it goes to litigation or arbitration, the end result, and with that experience and knowledge, I think it would be effective to mediate or facilitate settlement discussions. But without knowing that, it could be a bit of useless back and forth. So I'd suggest start your career with arbitration. Even better if you could become an arbitrator so that you get the perspectives, which will take some time, of course, but starting your career as an arbitration practitioner / litigation practitioner is something I would recommend.
Thank you, Mino. I'm just going to launch poll question 5, and I now invite Jay to provide his insights on that same question.
Sure. When I'm asked about careers in ADR and specifically in arbitration, I just remember 3 things. It is education, experience, and network. Education, take as much courses as possible. If you haven't learned it in law school, you should at least take some more courses. The practice of ADR is very dynamic. It changes almost every year, so you have to update yourselves. Next is experience. Go to a law firm that has a strong dispute resolution practice. If they, I hope they also have arbitration and mediation practice, which is much better, because from there you will really learn the ins and outs. You can also try to work for an arbitral institution, intern in an arbitral institution. That will also be very helpful just to open your eyes about how the practice looks like. And finally, networking, because in our field, I guess all of the panelists will agree that networking is very important. Put yourself out there, but make sure that you're known for the right reasons. And then if they know you, they know what you can do, and then let's say they give you a chance to be a counsel or be an arbitrator, they will stick with you because you've done your assignment, you've had the experience, and you had enough education to do the job.
Thank you so much. I think the question is, should we be arbitration counsel prior to becoming arbitrators, or should we just jump into, because I know, Jay, you've also acted as tribunal secretary. So do you think that it's necessary to be counsel first before one becomes an arbitrator, or can we do other things,
Well, for me, yes, you're right. I've been a tribunal secretary, I've been an arbitrator, I've been an arbitration counsel in an institution. I'm also an arbitration representative, and also in general a dispute resolution practitioner. I think you should first be a dispute resolution practitioner, be an arbitration counsel, because from there you gain the technicalities and you learn before you become, a tribunal secretary and or become an arbitrator. It's difficult if you become an arbitrator without you knowing how parties should act, how party representatives should act. It's very difficult on the management side of it, and even the legal side of it, if you're not used to being an arbitration counsel.
Great question. Actually, it reminds me of guerrilla tactics, which is a very big topic for another day.